A 68-year-old concealed carry permit holder was pulled over for a broken taillight. He had no criminal record, no warrants, no history of violence. He had been carrying legally for over 20 years, and he still ended up in handcuffs, not because he threatened the officer, not because he reached for his gun, not because he refused to comply. He made one mistake. And it is the same mistake most senior gun owners make the moment they hear those 4 words, "Sir, step out of the vehicle." If you are over 55 and you legally carry a firearm, what you do in the next 30 seconds after that command can determine whether you drive home safely or spend the night trying to explain yourself in a holding cell. Quick question before we go any further. Are you subscribed? Because what I am about to explain is something most gun owners never get taught in concealed carry class. Laws change. Court rulings shift standards overnight. And if you miss one update, you could be operating under outdated assumptions that get you arrested. Hit subscribe right now so you do not miss the next legal breakdown. Now let us talk about the mistake. Most seniors think the danger during a traffic stop comes from saying the wrong thing. That is not it. The real danger comes from moving the wrong way at the wrong time. Let us walk through this slowly. You are driving home. Maybe you just left the pharmacy. Maybe you picked up groceries. Your legally owned firearm is on your hip, in an ankle holster, or secured in your center console. Red and blue lights appear in your rearview mirror. Your heart rate spikes. Even if you have done nothing wrong, that is normal. You pull over. You put the car in park. You roll down the window. The officer approaches. He asks for your license and registration. You comply calmly. Then it happens. "Sir, step out of the vehicle." At that exact moment, most senior gun owners make one of 2 costly mistakes. They either move too quickly, or they move without speaking. Both can escalate the situation instantly. Now, before we go further, let us establish something critical. Under Supreme Court precedent, specifically Pennsylvania versus Mims, decided in 1977, once you are lawfully stopped, an officer has the legal authority to order you out of the vehicle. No debate, no argument, no negotiation. And that authority was extended to passengers in Maryland versus Wilson in 1997. So if your spouse is in the car, the officer can order everyone out, every single occupant, no probable cause needed. This is settled law. It has been settled for decades, yet I see senior gun owners challenging this every single day, and here is the problem with that. You do not want to be right about a legal technicality while you are getting handcuffed. Comply first. Talk to an attorney second. The street is not a courtroom. But here is what those cases do not explain in practical detail. How you comply matters enormously, and for senior gun owners, that difference is everything. Here's what went wrong in the case I mentioned at the beginning. The 68-year-old driver heard the command. He immediately reached down to unbuckle his seatbelt and shifted his body to swing his legs out. Completely normal movement, except he had not informed the officer that he was carrying, and as he leaned forward to unbuckle, his jacket lifted slightly, exposing the grip of his firearm. From his perspective, nothing threatening happened. From the officer's perspective, an armed man suddenly made a downward movement toward his waist while partially revealing a weapon. In less than 2 seconds, the tone of that stop changed completely. Voice commands became sharper. Hands moved toward holsters. Backup was called. The senior driver complied fully, but the situation had already escalated far beyond a broken taillight. Here is the painful truth. Officers are trained to interpret sudden waist-level movements as potential threats. They do not know your intentions. They do not know your medical limitations. They do not know you have carried responsibly for 20 years. They see movement first. They process intent second. And here is where age becomes a hidden factor most people never discuss. Many seniors move more slowly. Some lean forward to generate momentum before standing. Some brace against the door frame. Some shift their hips in ways that unintentionally draw attention to their waistband. None of that is suspicious in everyday life, but during a traffic stop involving a firearm, perception becomes reality, and perception can escalate faster than you think. So what is the costly mistake most senior gun owners make? They begin moving before clearly communicating. Silence during movement creates ambiguity. Ambiguity creates tension. Tension creates escalation. When you hear, "step out of the vehicle," your first move should not be toward the seatbelt. Your first move should be verbal, calm voice, steady tone. "Officer, I want to let you know I am legally carrying a firearm. How would you like me to proceed?" That one sentence does 3 powerful things at once. It informs, it shows compliance, and it transfers control to the officer. Control transfer reduces tension immediately. Then, and only then, do you narrate every single movement. "I am going to unbuckle my seatbelt with my left hand." Pause. "I'm opening the door now." Pause. "I am stepping out slowly." These words may feel unnecessary. They are not. They remove ambiguity. And ambiguity is the enemy during armed encounters. Also, here is something most people never think about. When you hand over your concealed carry permit alongside your license, the dynamic of the stop shifts immediately. Do not flip open your wallet where your permit sits beside other cards. Isolate the permit before handing it over. Announce it as you hand it over. I am handing you my driver's license and my concealed carry permit now. That verbal announcement keeps your movement intentional and removes all guesswork. Now here's the second layer of this problem. It involves the law in your specific state. Some states have what is called a duty to inform law. Some states do not. If you live in a state like Ohio, Michigan, or Texas, you are legally required to tell the officer immediately that you have a firearm. You say it calmly and clearly, "Officer, I have a valid concealed carry permit and I am currently armed. My firearm is on my right hip." You do not reach for it. You just inform. But if your state does not have a duty to inform law, like Florida, Pennsylvania, or Arizona, you are not legally required to volunteer that information. Here is the smart play, though. Legally required and tactically wise are not always the same thing. An officer discovering a firearm unexpectedly, even legally, can change the emotional temperature of a stop instantly. You do not want discovery to happen accidentally. You want it to happen verbally, calmly, and on your terms. Surprise helps no one. Now here is a third factor specific to you as a senior that most concealed carry courses completely ignore. The physical reality of your body versus the perception of the officer. Imagine you are 70 years old. You have a bad knee. An officer tells you to step out. It takes you 15 seconds to unbuckle your seatbelt, shift your weight, and swing your legs out. In those 15 seconds, a nervous officer sees someone who is not complying at a normal speed. That gap between your physical reality and the officer's perception is exactly where things go wrong. They do not see a senior with a bad knee. They see a driver hesitating to exit. They see potential concealment. They see risk. So communicate out loud as you move. "Officer, I am moving slowly because of my knee. Both my hands are visible. I am complying with your order." If you have hearing difficulty, say it. "Officer, I have hearing difficulty. Please repeat that clearly. Do not guess. Do not nod if you did not hear clearly." Misunderstanding an order during an armed stop can be charged as obstruction. Narration removes ambiguity. Stillness signals compliance. These words protect you with language while your body moves at its own pace. Now let us move to the conversation itself, because this is where senior gun owners face a completely different set of traps. You have stepped out, you have informed, you have narrated your movements. The tension drops slightly, then comes the question, is there anything else in this vehicle I should know about? Most senior gun owners think this is casual conversation. It is not. It is a doorway question, and how you answer determines whether this remains a routine traffic stop or turns into a 45-minute vehicle search on the side of the road. Here is the costly mistake most seniors make at this stage. They start explaining, "I have my prescription medication in the glove box. I have some cash in the center console. You can check if you want." That last phrase is the most dangerous, because the moment you say those words, you may have just given voluntary consent to search. And consent eliminates the need for probable cause entirely. Under the Fourth Amendment, officers generally need probable cause or a warrant to search your vehicle. But voluntary consent is one of the most powerful tools available to law enforcement. Consent does not have to be written. It can be verbal. It can even be implied by your words. If you consent, the officer does not need to establish probable cause first. You gave permission. That is why the wording of your response matters more than you think. Here are the 5 words you need to memorize right now. Write them down. When asked for consent to search, you say, "I do not consent to searches." Say it calmly. Say it politely, but say it clearly. "I do not consent to searches." This is not being rude. This is exercising your constitutional right. The full response that protects you in this moment is, "Officer, I do not consent to any searches, but I will comply with all lawful orders." That sentence does 3 things at once. It protects your Fourth Amendment rights. It avoids confrontation. And it signals cooperation without surrendering consent. Many seniors were raised in a culture where questioning authority felt disrespectful, where saying no to an officer felt wrong. But protecting your rights calmly is not disrespect. It is discipline. There is a massive difference. And if the officer responds with, "If you have nothing to hide, why not let me search?" That is a psychological pressure technique. It frames consent as innocence. But innocence and consent are not legally connected. Your calm response stays the same. "Officer, I respect your job. I just do not consent to searches." Short, clear, polite. Do not add explanation. Do not justify. Do not debate. After you have given your clear response, stop speaking. Silence is not suspicious. Rambling is. Let the officer decide the next step. Now there is one more scenario most people never anticipate. The officer says, "For my safety, I am going to secure your firearm during this stop." Your stomach drops. You wonder if this is legal. You wonder if you should protest. this is where another costly mistake happens. Some seniors tense up. Some say, "You cannot do that. I know my rights." Let us be clear. During a lawful traffic stop, courts have recognized that officers may temporarily secure a weapon if they reasonably believe it is necessary for safety. This traces back to Terry versus Ohio. Temporary disarmament during a stop is not confiscation. Most stops fall into the temporary category. So what do? You comply calmly. You do not reach for the firearm yourself. You keep your hands visible. You say, "My firearm is on my right hip. I will not reach for it." Then you freeze. Let the officer handle it. After the firearm is secured, do not say, "This is ridiculous," or "I have been carrying longer than you have been alive." Even if you believe those things, this is not the time. When the stop is over and the officer returns your firearm, do not rush. Wait until he returns to his vehicle and clears the scene. Then calmly resecure your weapon. Now here is the part most gun owners completely skip, and it is the part that can save your permit or keep you out of court months later. The moment you get home, before you pour a drink, before you tell your spouse the story, you document everything immediately. Your memory fades faster than you think. Stress distorts recall. Write down the date, the time, the exact location. Write down the officer's name, badge number, patrol car number, and the agency. Write down every question they asked. Write down every command they gave. Write down exactly what you said in response. First he asked for my license. Then he asked me to step out. Then he asked about the firearm. Write the sequence. If there was any damage to your vehicle, photograph it. If your firearm was handled, note its condition. Was it returned correctly? These details create a record that protects you. If you are a member of a concealed carry legal defense organization, contact them the same day. Not because you did anything wrong, but because if the officer filed any paperwork about that stop, you want your version documented while it is fresh. If you are not yet a member, consider it seriously. The cost of membership is a fraction of 1 hour with a criminal defense attorney. Now, here's something that changes everything about how these stops are legally evaluated. In May 2025, the Supreme Court decided a case called Barnes versus Felix. A man named Ashtian Barnes was stopped for suspected toll violations. When the officer ordered Barnes to step out, Barnes began to drive away. The officer fired, killing Barnes. Lower courts had been using what was called the moment of threat doctrine, which said only the final second before force was used could be evaluated. The Supreme Court threw that out entirely. They ruled that courts must look at the totality of the circumstances, every action, every decision, every command in the entire sequence of events. Why does this matter to you? Because it changes how courts evaluate everything that happens during a traffic stop from beginning to end. If an officer acts unreasonably, if they ignore your narration of mobility issues, if they escalate when you are clearly complying, the entire sequence can now be reviewed. Your documentation becomes the evidence. Your written record shows the totality of what happened. 6 months from now, sitting in a courtroom, you will not remember the exact words the officer used, but your written record will. And that record could be the difference between a dismissed case and a conviction. One more thing before the final rules. Body language. Once you are standing outside the vehicle, keep both hands visible at all times. Do not cross your arms. Do not put your hands in your pockets. Do not lean casually against the car. Posture communicates attitude. You want your body to signal calm, compliant, and stable. If you need to adjust your stance because of a joint issue or back pain, announce it first. "Officer, I am shifting my weight because of my back." Every unexplained movement is a question mark. Every narrated movement is a period. You want periods, not question marks. Let us bring everything together into 4 rules every senior gun owner must memorize before they get back behind the wheel. Rule 1. Always comply when ordered to exit. Pennsylvania versus Mims is settled law. Your age does not exempt you, your permit does not exempt you, but speak before you move. Inform before you act. Rule 2. Know your state's duty to inform law before you carry. This is not optional. It is mandatory knowledge. But even in states without a legal requirement, inform anyway. Surprise helps no one. Clarity keeps everyone safe. Rule 3. Narrate every movement, especially if you are slower due to age or physical limitation. I am reaching for my registration with my left hand. I am moving slowly because of my knee. These words remove ambiguity. They protect you with language while your body moves at its own pace. Rule 4. After the stop, no matter how it went, document everything immediately. Date, time, location, officer name, badge number, what was said, what was ordered, what you complied with. This is the beginning of your defense. It is your shield in a courtroom. Here's the bottom line. When a police officer tells you to step out of the car, you comply. That has been the law since 1977. But how you comply, what you say, how you move, how you communicate that you are a legal gun owner, that is where your safety and your rights either get protected or they do not. The Supreme Court has made it clear that what happens during a traffic stop matters from beginning to end. Every word, every movement, every second. As a senior gun owner, you have every right to carry. You have every right to be treated with respect. And you have every right to go home safely after every single traffic stop. Preparation is not about fear. It is about freedom. The freedom to live your life without anxiety. The freedom to know that if those lights appear behind you, you are ready. If this helped you, do one thing right now. Subscribe. Laws evolve, standards shift. Court rulings reinterpret old doctrines in new ways. Staying informed is no longer optional for responsible gun owners. Share this with one senior gun owner in your life, a parent, a friend, a neighbor, someone who carries but may not realize how fast 30 seconds can change everything. Drop your state in the comments below. Laws vary dramatically by state, and your location matters. Legal disclaimer, everything in this video is for educational purposes only. It is not legal advice. Gun laws vary significantly by state. Always consult a licensed attorney in your state for advice specific to your situation. Do not rely on this video as a substitute for professional legal counsel. Stay calm, stay disciplined, and make sure the next time you hear, "step out," you are prepared, not surprised.